we might be just right off of work or might be a little bit late in the evening for the East Coasters like me. Maybe you're right in the middle. But I appreciate everyone taking time out of their day to come to this webinar. My name is Grina Kim. I am the Director of Wellness and Wellbeing at AAVMP, and I'll be moderating our webinar tonight. So I'm going to introduce our wonderful speaker, Jo-Anne Yau. She is a lawyer who represents healthcare professionals in issues involving discrimination and harassment in the workplace, liability and professional grievances, business growth and management, academic integrity, and intellectual property portfolio development. She's licensed to practice law in the US and Canada, and she has a postdoctorate degree in internet law from Scotland. Jo-Anne's community initiatives are focused on supporting entrepreneurs, women in business, youth in sports, the Asian community, and emerging markets. And we're really happy to have her talk with us today. And I just want to make everyone aware that actually what prompted this webinar today is a message from one of our members who messaged us through our website on our message board, talking about an experience that they had in their workplace with discrimination. So I just want to make everyone aware that we do check our message boards. We are open to ideas about different topics that you guys want to hear about. Without further ado, thank you, Jo-Anne, and you can go ahead and take it away with your talk.
Great, thanks so much. I appreciate that introduction. I'm going to go ahead and share my screen, and ideally, it'll go exactly as I tested it, so you guys could see both my slides and hopefully me as well, but more importantly would be the slides. So, you can see the slides, right? And I don't know if I'm okay. All right, so again, thank you for that introduction. I'm Jo-Anne Yau, and I'm so delighted to be here talking to all of you today. Of course, this presentation will be recorded, and you're welcome to contact the AAVMP to watch it. But in addition to that, for those of you wondering if I'll be sharing the slides, I will indeed be sharing them. I just need to then get rid of my speaker's notes, and I'll be distributing them for whoever is interested in it, so you don't have to worry about writing anything down in a flurry. You can just sit back, relax, and after your long day, enjoy a wonderful discussion about discrimination and harassment. One other thing I wanted to mention is I'm typically really open and casual about question and answers. I'm not able to see a chat box or anything like that, but if anybody has a burning question as I'm talking, feel free to maybe put it in a message board, and if somebody could, flag me or just let me know that you had a question, I'll be happy to answer it. But at the end of the presentation, I'm also going to have a Q&A session too. So either way, if you want to stop in the middle or if you want to wait to the end, happy to answer any questions. And one other note before I get in the weeds of this discussion, of course, being a lawyer, you probably know what's going to be coming up. Well, the tone of this presentation, it's my intention to give you an informative, and at times I hope it's going to be positive and humorous. But I do have a disclosure. There's trigger warning and legal advice disclaimer because we are going to be discussing some sensitive topics. So I wanted to let everyone know ahead of time what they were. If you're not comfortable with these topics, or if it's something you don't want to go through, it's always something I can, if you wanted to contact me for the law side of it later, I can give you the abridged version. But I will be bringing up examples that include discussions about mental illness, hate-based speech and conduct, substance abuse and addiction, physical and sexual abuse, and abortion and or fetal and infant loss. So if you find this upset or otherwise triggering, again, feel free to step out, and I can catch you up on an abridged version of this presentation. And if you do decide to stay on, but then after hearing the conversations about these topics, you feel you need support, I know that your members are all over North America, all over the world, so I wouldn't have a list for you, but contact your local support and services in a jurisdiction near you. And the final disclaimer is that because I'm both US licensed in Florida and Canadian licensed in Alberta, I wanted this presentation to be very accessible and usable by everybody. So this presentation is going to be really about legal principles. And so you can't really rely on it for legal advice. It's not jurisdiction specific. and it doesn't form a lawyer-client relationship. So talk to a lawyer licensed in your jurisdiction about any of these topics that we're talking about if you have questions. Also, feel free, if you have the slides or the recording and you want to play it for that lawyer, feel free to do so as well. But if you are in Alberta or in Florida, I could be that lawyer for you to fill in the gaps. All right, so I'm going to give you a roadmap of where we're going to go and how we're going to get there. I'm first going to set the stage with employment and workspace context, because that's going to largely dictate about the relevance of our discussions to your employment situation. Then I'll talk about discrimination and harassment as definitions within the workspace context. And then I'm going to break it down and talk about each of them individually. So under the discrimination heads, I'm going to talk about human rights and civil rights, the protected class of people that are affected by discrimination. We're going to talk about what discrimination looks like and what happens when a class-related need arises in a discriminatory context. I'm also going to be talking about employers' defenses when you point the finger at them and say, you're acting in a discriminatory fashion. They say, yep, I am, but here's the reason why I'm justified in doing so. So that's going to be an interesting conversation. I'll then parlay into harassment and violence and really get into the obligations to prevent harassment and violence, both through actions and by policy. I'll then provide some FAQ scenarios. So rather than opening up just yet, I'm going to give you some scenarios that apply the topics and principles that I presented, just so they're going to be in a little more user-friendly fashion. And then I'll open up the floor to a formal Q&A. All right, so let's go ahead and start with these employment and workspace contexts. And the reason why I set this up is because largely the conversation and the whole presentation I've got today, it relates to formal employment agreements, not so much independent contractor relationships. And the reason why formal employer-employee relationships are going to trigger these duties and concerns about discrimination is because, at least in North America and, in Canada and the US, employers are deemed to be in a position of stronger bargaining power in that employer-employee relationship. So employers owe their employees enhanced duties just by virtue of that employment relationship. And I want to contrast that then with the independent contractor arrangement, because in that scenario, who you might think is the employer is actually called the client, because they're the one receiving services and paying for the services. And what you would think of as the employee is the actual independent contractor. And in this kind of independent contractor / client relationship, both parties are deemed to have equal bargaining power. And that's why when there's that equality in bargaining power, one doesn't owe the other a duty to protect the other from evils and harms and so on and so forth, the same way that you would see in employer-employee relationships. And I do want to make one point quite clear, because I do have a lot of clients who are physicians, chiropractors, aesthetics doctors, dentists, and I don't really know what it is about professionals in the healthcare space, but I have often seen, particularly when we have a clinic owner, and they want to bring in an associate or a junior professional, and of course the clinic doesn't want to take on this junior's liabilities or tax withholdings or any of that. So the clinic typically offers on the document, it says, this is an independent contractor agreement, and I'm going to bring you on as an independent contractor. Therefore, I'm not responsible for anything you do. You're responsible for your own taxes, your own liabilities. If you get sued, it's just you. And that's fine to do. However, there's something called the duck test applies. And I'm not saying the duck test because you're all veterinary medicine folks, but you've probably heard of, if it walks like a duck and it quacks like a duck and it looks like a duck, it's probably a duck. So the duck test applies here in employment relationships. So even if a clinic has entered into what's called an independent contractor relationship with a younger professional, and the document says, well, we're in an independent contractor relationship. If the nature of the relationship, the control over the relationship, if everything checks the boxes under an employment contract, in that case, then that relationship is going to walk like an independent contractor, quack like an independent contractor, and look like, or I'm sorry, that independent contractor is going to walk like an employment contract, quack like an employment contract, and look like an employment contract. And thus, it's actually going to be interpreted by the courts that there is, in fact, an employment contract relationship. And it puts the clinics in a really, I guess, precarious and difficult position then, because they've always entered this relationship with the understanding that they didn't have an enhanced duty or liabilities or responsibilities to their now employee. But now they're exposed to, let's say, paying back taxes, absorbing any liabilities that might have come up. So it's always best to understand what the nature of that relationship is between the two parties before you go ahead and put something in paper. So when we go ahead and we start with the nature of this relationship, when you're in an employment contract, it's basically called the employer and employee. But under the independent contractor, the service provider is kind of the employee because they're providing the service, and the client is kind of the employer. But it's just that we use the different terms for the different relationship. One of the hallmarks of that relationship then is who dictates the schedule, location, and job directives for the employee. In an employment contract, it's the employer. Employer tells you when to go, how to get there, and what your schedule is going to be, when you have holidays. But as a service provider in an independent contractor relationship, it's one of the key components of you being responsible for your own work is that you can come and go as you please and you set your own hours, all those kinds of things. Same goes for whose tools and equipment is used. In an employment relationship, it's going to be the employer providing tools, rooms, probably like the cleaning and sanitizing equipment, all those kinds of things. But in an independent contractor relationship, it's the service provider who provides all those things on their own, and a lot of times they bring that on site with them to perform the services. Again, the who withholds taxes is usually the big reason why clinics like to say that it's an independent contractor relationship, because if it's an employment contract, the employer has all those duties to do it. When it comes to termination obligations, as far as terminating that relationship, if it's an employee-employer relationship, there's going to be probably statutory and common law minimums. So what that means is that the employer, owing a higher duty to the employee, has to give certain notice to this employee before letting them go, providing certain pay guarantees, maybe even some severance as well. But if it's an independent contractor relationship, then the parties just terminate pursuant to the termination clause of their contract. And it's really however they decided to agree to terminate is the termination. And there's no duties owed one to the other. Now, when I say the next box being non-discrimination obligations, what this means is that one of the parties has an obligation to protect the other from discrimination. Okay, and so of course in an employment contract, it's the employer who has whose workplace decisions cannot be based on the employee's membership in a protected class. So the employer has a duty to protect employees from discrimination. Whereas if it's an independent contractor, that client owes no obligation to the service provider at all. They don't have to protect them from anything. And finally, also safe workplace obligations. And I mentioned this one because when it comes down to the issues of harassment and violence, those fall both under discrimination and also under like OSHA or other safe work environments. And the employer does have a duty to keep their employees safe, not just from physical hazards like tripping, falling from heights, weights falling on them, getting burned, but they also have to provide to their employees a safe environment free from harassment or violence. But again, in an independent contractor relationship, that client only owes a duty to maintain a reasonably safe environment. So, and that's referring to a physical environment. So the independent contractor isn't coming into a workspace that's full of tripping hazards, falling hazards, or anything like that. All right, so let's get into the definitions of discrimination and harassment in the workplace. And these two words, they're two very different yet related monsters. And they do often appear together, though not always. So what we have here is the differences between the two of them. So what you're going to see here, I'm going to highlight at a high level. Discrimination is really not personal to the target. It's not conduct that's personal to the person, but it's more how someone is treating a characteristic that target has. And generally, harm is not usually intended on the person because the object of the discriminatory acts are geared towards whatever that characteristic is. But on the other hand, harassment is going to be more insidious, and it is personal to the target for the most part. And usually when there's harassment, negative impact on the target is intended. So we're going to explore these separately. But let's start with discrimination. And really, when we go through discrimination, the discrimination description here, take a look at these blue highlighted terms I have here. Discrimination really is a set of stereotypes about somebody's background rather than that person's objective individual traits that leads to assumptions that this person is maybe less worthy of respect, less trustworthy, has poor work ethic, difficult to train, all these assumptions that go with a trait that's associated with a person's background. And as such, because of these assumptions, then this employee has imposed on them burdens or obligations or disadvantages. And there might be limitations to them, like as far as opportunities, benefits, and advantages that are available to other members of society. So things like maybe a pay raise, maybe a promotion, maybe opportunities to expand their professional skills and knowledge. Okay, so that's all under the gambit of discrimination. And so when we talk about discrimination, though, I'll use myself, a lawyer, as an example of when discrimination can appear and when it might be permissible. So let's just say that I've retired today as a lawyer, and I've quit my job, and now I want to start working for an advertising company to come up with marketing campaigns. And my boss, who knows that I was a lawyer, refuses to assign me any big clients because, well, they think that for me as a lawyer, lawyers aren't worthy of respect. Lawyers are not very trustworthy. Lawyers have poor work ethic. Lawyers are difficult to train, so on and so forth. So my question then is, because my boss is treating me differently on account of my background, is that discrimination? And the answer is, well, yes, but it's not really something that's actionable discrimination, at least not under human rights or any of those types of those fundamental rights to me, because the reality is that employers do have a lot of latitude to make business decisions that their leadership considers to be in the best interest of the company. So maybe it could just very well be that the stereotypes of me as a lawyer are accurate, and my boss has good reason to keep the big clients away from me. So that kind of unequal treatment between me being a lawyer in a marketing environment, being treated differently than my other colleagues in the marketing environment, that type of unequal treatment and the conflicts that could result from that, the courts will deem that to be an expected aspect of life and workplaces that I just need to suck it up, buttercup, and deal with it. Now, there are times though, like, so this is an example where my background as a lawyer can be used against me to quote unquote discriminate. So now let's talk about when it's not acceptable for an employer to discriminate. And that's when human rights laws have identified protected classes of people. And these are the labels that, that employers are not allowed to use in a discriminatory fashion. And in addition to these terms here, I've added a couple extra ones with asterisks because depending on the jurisdiction, in addition to all those other classes like race, color, family status, disability, marital status, some jurisdictions will recognize your political beliefs, your criminal record, and your gender identity and gender expression also as traits that should not be used against you in a discriminatory fashion in employment settings. All right, so when we talk about all the ways, all those other labels, those protected classes that employers are not supposed to discriminate, then when we do see instances of discrimination, what does it look like and what are we dealing with here? So there's three classes of discrimination: direct, indirect, and systemic. So when we talk about direct discrimination, this is really the most obvious kind of discrimination. It's when an employer generalizes about an individual's ability to perform a job based on perceived membership in a group sharing that characteristic. And the example here is if an employer said, no women may be hired as firefighters. Okay, so this policy of no women may be hired as firefighters has a direct effect of excluding women from employment. And that discrimination is obvious. Now we move into the next category, though, of indirect discrimination. And indirect, depending on the jurisdiction, they might call it adverse effect discrimination or constructive discrimination. But in indirect discrimination, that discrimination is a little more subtle, and it's when an employer adopts a certain standard that's neutral on its face, which means that it looks like it could pass muster, that it's not really discriminating on one of those protected classes, yet that particular policy actually still has an adverse effect on one of those protected groups of people. Okay, so an example here is all firefighters must be at least 6 feet tall. Okay, and so the reason why this is indirect discrimination is because it's not necessarily saying that women cannot be firefighters, but it's the fact that there are not very many women candidates who are 6 feet tall. So on its face, it looks like this is a very neutral policy, but it does have the indirect effect of excluding many women because they don't reach that height requirement. Then finally, we have systemic discrimination, which is obviously the most probably insidious of them all, because this is one where it's not even just the employer and the employer's perspective on discrimination that's really the harm here. That this discriminations arising out of some established practices or patterns of behavior that have been perpetuated through society and have a negative impact on hiring, employment, advancement of the members of the group. And it's really quite subtle because you see it in the society so often that sometimes we don't see it or identify it as a factor that's just discriminating against a protected class of people. So when we take a look at the example here that for the firefighter candidacy, if we say that male candidates are encouraged to apply for the firefighter position, that kind of policy is set on the rationale that women are not suited for the job or the work environment. So even though, as you can see, that the example is framed as a positive of who they want to apply, it's reflecting some systemic discrimination that women are unfit or unable to perform the jobs, and therefore it's one of those exclusion by omittance, that you're not saying that you're omitting women from consideration, but the fact that you're highlighting another party, that's what brings up the discrimination against women. All right, so when we talk about discrimination, though, there are some cases where those class-related needs arise. So in the examples I've got here in that box, and this first example is geared towards the protected class of the family class. Okay, so let's say an employee's spouse had an abortion or suffered a miscarriage. Okay, so that's considered to be a family circumstance that the employee is going to need some accommodations. Or we might have, in the second example, it's a disability issue. So when we have a police officer employee who's on beat, and that's kind of the police terms to say that they're on the streets, they're kind of live on beat on the street, driving on foot or what have you, but they're diagnosed with anxiety, and that anxiety diagnosis doesn't make them fit to be on beat on the streets and patrolling their jurisdiction. And then also, here's an interesting one where, and it's of particular relevance in Canada and some states in the US that have legalized the use of cannabis. And so they have recreational cannabis use and they have medicinal prescription cannabis use. So it's the last example here of the crane lift operator employee needing to smoke marijuana every 2 hours. This actually it's a trick question, because it's actually got two different interpretations based on a little piece of information I didn't give you. And what I didn't give you is whether that employee needs to smoke marijuana every 2 hours for recreational purposes or for medicinal and prescription purposes. Because if it's for recreational purposes, now this crane lift operator is falling outside any of those protected classes. Okay, it's not for disability, it's not for medical reasons, and so in that particular scenario, an employer could say, hey, crane lift operator, no smoking marijuana, you're out of here. That doesn't apply. However, if you inserted there the fact that this crane lift operator needed to have marijuana every 2 hours for medicinal purposes, Now that's going to trigger the fact that the crane lift operator has a disability, and an employer cannot necessarily exclude that crane lift operator from taking his necessary medications, because that would be discriminating against his medical need and disability. So this is where we come into, in situations like this, how do we accommodate all three of these types of employees for the needs that they have? For the employees with a spouse who had the abortion or suffered a miscarriage, the accommodation is going to be under family class. For the police officer, it's going to be under disability. And then crane lift operator, depending on his need, he might need accommodation for, again, his disability, or no accommodation at all, because it's not a protected class to be able to use marijuana on a recreational basis. So when we're looking at ways to accommodate people who did have a need arise under their protected class, both the employer and the employee in almost every jurisdiction have a duty to work together to try and find an accommodation that will work for that employee. So here the employee needs to come in and provide information about the nature of their disability or whatever their protected class is. They need to also accept reasonable proposals from the employer to fulfill the employer's duty to accommodate that employee's needs. And the employee also needs to facilitate implementation of accommodation. So they can't be stubborn and demanding of how that accommodation is provided. If it sufficiently addresses the employee's needs, then that's all part of the employee's reasonable acceptance of accommodation. So on the other side, again, the employer, having a heightened duty to the employee, does have a duty to accommodate. And the two aspects of that duty to accommodate is working with the employee, and sometimes also in conjunction with occupational specialists, to determine what accommodation is appropriate for the disability and for the job that needs to be done. So for instance, that crane lift operator, even if there was a medical requirement for to consume marijuana, if an occupational or vocational expert came in to assess the crane lift operator's ability to operate that crane after having taken his medicine, I would bet money that the crane lift operator would not be able to perform the duties of operating heavy machinery. And so there would have to be an accommodation for that crane lift operator while his body is still under the influence of, whatever substances are affecting his ability to think clearly or perceive things appropriately. The second part of the employer's duty is the duty to offer accommodation. So again, the employer needs to then assess factors like the cost of offering the accommodation, whether it's possible to offer the accommodation, whether they can shuffle people around to give maybe the employee a desk job while they're not able to, let's say the police officer can't walk the streets, maybe he can do paperwork. So it is going to be a collaborative effort between employer, employee, and sometimes also medical specialists as well. So the big question that I get asked, because I do work for employers on the employer side too, is, well, to what extent and to what point do we need to continue accommodating employees and their protected class needs? And the answer there is until the employer suffers undue hardship, which is essentially just saying until it's beyond reasonable for the employer to keep accommodating the requests of the employee. And there's no magical rule as far as determining what factors will allow an employer to tap out of accommodation duties on basis of undue hardship. But some factors would be, whether the safety of the organization or the team is compromised by the accommodations, whether the financial cost is going to be too burdensome, maybe overall organizational disruption of having that employee accommodated. That's a good reason to tap out of accommodation based on undue hardship, or even the negative effects on the morale of other employees to have the accommodated employee be accommodated. That's also a reason to stop accommodations on account of undue hardship, because at the end of the day, the employer is there to still run a business and make money. And if they can't do that, then the courts will relieve them of their duties to accommodate the employee. So there are instances, though, when an employer may be discriminating against a prospective employee on the protected classes, and it's still permissible. Okay, and so one, and probably the top number one reason that I see most often, that I litigate the most often, is when there's a bona fide occupational requirement, called abbreviated BFOR, and some jurisdiction will call it BFOQ, bona fide occupational qualification, which is a good faith occupational requirement that the employee is able to perform the duties of this specific job or function. So let's say a BFOR of airline pilots, the airlines could say our airline pilots must have 20/20 uncorrected vision. Okay, and when you think about the importance of airline pilots not having to depend on contact lenses or glasses, or not have to squint their way down a runway, so it's a bona fide occupational requirement that airline pilots automatically have perfect sight, perfect vision to do what they need to do to fly a plane. So even though it's going to discriminate against a whole class of people who need corrected vision, which is obviously a protected class, being the class of disabled, they'll call it disabled people, there still is a BFOR to allow airlines to choose airline pilots with perfect vision. Same thing as our firefighter example before. We could impose a requirement that all firefighters must be able-bodied, 2 arms, 2 legs, 2 hands, 2 feet, because it's a BFOR, a bona fide occupational requirement, that firefighters are able to quickly and effectively rescue people from burning buildings. Okay, so even though the hiring requirement of excluding people who are maybe disabled or don't have perfectly functioning limbs, that is technically discrimination that violates human rights. That still is something that would be considered as a defense to the employer's hiring on those basis. And I should also note as well that there are some classes, protected classes, that are never going to qualify as a BFOR. And those classes are going to be race, color, and national origin, because the courts have viewed time and time again that there's never any reason why you need to discriminate against someone's race, color, or national origin to be able to perform a job. Those are just not qualities that would qualify or unqualify someone for any particular job. Now, the business necessity exclusion or defense is an interesting one, because it basically says it's a policy or practice that has a disparate impact on a protected group, but it's justified. So if I give you the example of an Amazon driver must be able to lift 50 pounds, well, it impacts candidates who might be, let's say, older. Let's say if an elderly candidate couldn't lift 50 pounds to become an Amazon driver, that technically is discrimination based on age. Or it could also have an effect on women, and which is infringing on that protected class of gender groups, because women tend not to be able to lift as much as men. So here, though, because it's part of the job, and it's not quite a BFOR, because it's not quite a requirement of a job to be able to lift 50 pounds, but it's business necessity that they can. And so on that hiring basis, it could result in Amazon drivers ending up being more likely younger people and male. Now, the same actor inference is a really interesting defense when an employer is accused of either not hiring somebody on improper discrimination factors, or terminating somebody based on one of the protected class factors. What the same actor inference is that the same person who does the hiring, if that same person also does the firing, then it cannot be that that person is hiring or firing based off of discriminatory reasons, because otherwise they wouldn't have hired the person in the first place. And it must be something beside the quality of the candidate that caused the firing. So maybe it was performance, maybe it was that they're showing up late all the time. But the fact that you keep that one factor consistent, the same actor doing the hiring and firing, that often serves as a defense for employers to act in a way that could be perceived as discriminating against a protected class. The charitable organization defense is also a defense to employers acting in a way that appears to be discriminatory. And it's because charitable organizations, their primary purpose is usually to promote the interests of an identifiable group. And usually this group is marginalized or disadvantaged people. I put this domestic employee there. It's kind of a weird one, but that one's provided by statute by some jurisdictions. And there's really no rhyme or reason why housekeepers and nannies, who are described under domestic employees, are excluded from the protections of the human rights categories. But if it's in the statutes, it's permissible. And of course, the last one, there's the legislatively permissible reasons to discriminate against an employee. And it could be for the reasons of their pensions or their health plans. It could be affirmative action plans and initiatives that have already been started. Or it could be on diversity, equity, inclusion, and accessibility initiatives that have been started. Those could all be reasons to hire and fire based off of one of the protected classes. All right, so if you recall this slide with the two-headed monsters, we talked already about discrimination, and I'm going to move now over to the definition of harassment. And harassment is discrimination when the recipient is targeted for being a member of those protected classes, race, religious beliefs, color, gender identity, but also that there could be the risk of exposure to violence associated with that harassment, because harassment is targeting that particular individual for offensive or humiliating conduct, comments, bullying, sexual solicitation, or sexual advances. And oftentimes, when that harassment escalates, it can often escalate into violence, which turns into conduct that causes either physical or psychological injury or harm. And that's also targeted to the person as well. And a lot of times too, the violence will manifest itself as sexual violence, violence towards gender diversity, intimate partner violence, and domestic violence as well. So if we were to talk about harassment and violence, what I want to discuss about these two particular concepts is that there are built into, at least North American laws, an obligation to prevent harassment and violence in the workplace. And as I mentioned, it can be done by actions and it can be done by policy. So when it's directed to be done by actions, to prevent harassment and violence, the overarching theme is that prevention of these two harmful outcomes is everyone's responsibility. So everyone, employer, supervisors, employees, must take reasonable steps to prevent them. And for employers, they have to prevent or minimize workplace bullying and harassment. And that's across almost every jurisdiction. Employers have the obligation to prevent that. Employers also have an obligation to prohibit knowingly permitting the harassment of a worker. So if they see somebody in their staff who's being harassed and they know about it, they cannot pretend to turn a blind eye. That's what that point means. And finally, employers have to ensure that no employee is subject to sexual harassment. A lot of those same duties of an employer are also imposed on a supervisor as well, because the supervisor has those kinds of powers over the employees. So, but because the supervisor tends to have a closer working relationship than sometimes the employer does, supervisors are also tasked with not engaging in the bullying or harassment. And they're also tasked with applying and complying with the employer's anti-bullying, anti-harassment, all those kind of policies and procedures. And they also have to prohibit any kind of turning a blind eye type of action. Now, finally, employees also do have an obligation to prevent harassment and violence in the workplace. And I put employee with an asterisk there because this is a special circumstance where employee also includes volunteers in an organization, independent contractors, and dependent contractors in some jurisdictions. And I know I started off this presentation by saying that independent contractors are largely going to be excluded from this conversation. In the context of harassment and violence, because those are so harmful to people and to society, the protections that are afforded to employees and the duties that employees have to protect themselves is also expanded to include independent contractors, volunteers, and dependent contractors. And what this class of workers, I should say, is to not engage or not to exchange bullying or harassment. They have a duty to report it as well, and to apply and comply with the employer's anti-bullying and anti-harassment policies and procedures. All right, so when it comes to, we talked about in the last slide, obligations to prevent harassment and violence by action. This is preventing it by policy. And I know I've got a lot of words here, but I want you to pay special close attention to the words that I've highlighted in blue, because those are going to be the key terms here. So the obligation to prevent harassment and violence by policy can be done by implementing these policies and programs in the first place. They can be done through policies by hiring key personnel. And these key personnel can have official names or titles in the organization, or they could be consultants who are brought in. But when an organization has by policy key personnel who are supposed to come in and identify these particular instances, those go a long way to help prevent the harassment and violence in the workplace. We also have the employer's duties. Of course, it's a long litany or laundry list here of what the employer needs to do to protect his employees. So employers have duties to train and educate, to assess and report the risk of harassment, to minimize and mitigate or entirely eliminate the risk of workplace environment. So on and so forth. The employers do have to take active action in the work that they do around their organizations. And finally, no policies are going to be any good, even if you have the people, even if you have an employer, if you don't establish consistent procedures for executing on those policies. So those procedures are going to include disclosing previous incidents, reporting current incidents, finding a way to get assistance to those who need it, and things to that effect. All right, so now that I've talked a lot of theory on the principles, I'm going to introduce now some FAQ scenarios for you to think about applying the principles that we discussed. So first question is, what if my employer fails to reasonably accommodate my protected situation? Okay, so what are some things that this employee could do? Really, when it comes down to it, of course, that employee could talk to the employer, have meetings with HR, maybe send a demand letter, maybe hire a lawyer and lawyer up. But fast forwarding all the way to the end of the book and reading the last page first, the final step that the employee is going to have is to file a human rights or civil liberties grievance with the state or province's commissioner. And those are typically, because they are governed by state and province by province, there's no really one set way to go ahead and do that. But if you are an employee who has tried everything to get a resolution on your discrimination, on the discriminatory conduct, I would encourage you to even just say, Google your jurisdiction, so maybe your province, like Ontario, Human Rights Commissioner, and see how you can enter grievances that way. I put civil liberties in there too, because for the American members would be using in Googling civil liberties with their search for a commissioner to report the grievance. The next question is, are microaggressions in my workplace reportable as human rights or civil liberties breaches? And for those not familiar, microaggressions are they're indirect or subtle or unintentional discrimination by words or actions that occur in everyday life. So it doesn't seem like they are that it's discriminatory, but it is ways indirectly and subtly to discriminate against someone. And the way you would approach microaggressions, because they are indirect and because they're subtle, is first, there needs to be a determination as to whether discrimination is the basis for this microaggression. Okay, so if the discrimination is on the basis of membership in an unprotected class, so again, let's take the example of me being discriminated against because I'm a lawyer, now finding myself in a marketing environment, that's an unprotected class. So really the best I could do in that scenario is I could report it as a complaint internally to whoever in my hierarchical corporate environment will listen. And really to actually know what my other options for recourse are, I would want to talk to a lawyer in that jurisdiction to see what other statutory or legal options I might have to stop this microaggression against me on an unprotected basis. However, if that discrimination is on the base of a protected class, that's where the employee would qualify to report it as a human rights or civil liberties breach to the commissioner. So same answer as the first question. But now I want to take the discussion about discrimination, harassment, and violence outside the employment context for your consideration, and consider what can you file a grievance over, even though it's outside employment context. So the answer is jurisdictions will differ, but only slightly, I bet. And here's some examples. So let's say we have a taxi company who doesn't have any wheelchair access taxis. How about a hotel that has a note that doesn't have any smoke-free rooms for asthmatic guests? How about a university who has no supports during classes or exams for students with physical or mental disabilities? And we could go on and on here. These are non-employment contexts where there is discrimination based off of these protected classes. And the answer is actually yes, you can still file a grievance on those discriminatory actions. And finally, the last question here that everybody loves to ask is, do I need a lawyer to do any of this? And the answer is a very lawyerly one, because it's not clear and very clear all at the same time. You don't ever have to have a lawyer, but what you need to ask yourself is, do you want one? And when I talk to my clients, not even just in employment context or discrimination or anything like that, anytime someone comes to me for a consultation to talk about their legal problems, and at the end of the consultation, we get to the discussion of whether they want me to do some additional work for them and be retained as their lawyer. I basically break it down to the 3 resources that I recommend the client consider. And that's their time, their money, and their energy. And that will determine whether you actually want a lawyer. So if you're really short on time, if you're a very busy person, then yeah, you might want to hire a lawyer to help you get the legal work done. If you're short on money, then chances are you might not want to get a lawyer because the lawyer's bills might haunt you for quite some time. But if you have the resources to invest into a lawyer, then oftentimes being able to offload that task, the same way you might offload the task of hiring a housekeeper to clean your house, or going out to dinner instead of cooking your own food. Lawyers are really pretty much the same way. You could do everything yourself, but if you can afford to throw money at it and make it go away, a lawyer can take that grief off of your plate. And finally, the energy aspect. And I kind of saved this one for a little bit last because in a lot of business disputes that I work through, people are just fighting over money. There's really no emotions, no high stakes. Nobody's going to lose their kids or their house or anything like that in the kind of work I do, except in employment situations where there's discrimination involved. In that case, there's already going to be instances of feeling discriminated against, feeling like the world's been treating you unfairly, that your employer's treated you unfairly, or maybe from an employer side that an employee has been taking advantage of you. So there is an emotional toll to moving forward with any kind of legal issues, and that taps into your energy. If someone has had their emotional resources really tapped out and exhausted, that they're cognitively just not really able to handle this themselves in a way that they could move forward with clarity and with good intention, then I would recommend them have a lawyer to take that stuff on. And really, all they would do is go to the lawyer to get explanations and to give instructions. And because I tend to find that when emotionally exhausted people try and do the cases themselves, they often get too far into the weeds, and then it doesn't serve their purposes. All right, so Finally, that is the end of this presentation. And I wanted to leave you guys a little more time for questions, but we do have some time still. I loved finding the little animals to put on my Q. I like to end my Q&A slide with my contact information, but also something thematic to my audience. So you can find me on LinkedIn. I'm pretty active on LinkedIn. If you want to connect with me, please do, and we can chat some more about the presentation. I am also on X. My handle is Innovative Litigator. My email address is up there, and you can also call or text me. That's my business line. And so if you have any burning questions and you don't want to pick up a phone, you don't want to bang on email, feel free to call me or shoot me a text. And with that, I'll be happy to take on any questions.
Awesome. Thank you so much for that great talk. Wow, I actually learned a lot. Because I feel like generally I just thought of discrimination and harassment as these kind of nebulous things, but to really have that legal definition was really helpful. So does anyone in our audience have any specific questions about the presentation or anything else? I do see one question in the Q&A that's asking if this will be recorded, and yes, this presentation is being recorded and will be available for you guys if you join late. Well, if no one else has a question, I did have a question about the part where you talked about the hiring and firing, that if they're the same person, then it doesn't count as discrimination. Was that correct?
It's not that it doesn't count, but the presumption there, and I'll flip back to that slide because it's great. That's a great question. The presumption there is that the person who did the hiring obviously didn't make that hiring decision. And this is that same actor inference here. The person who did the hiring obviously didn't have any discriminatory motives in a way that would infringe upon someone's protected class rights. And so if it's that same person who did the firing, then the inference is that, well, if they didn't hire based on discriminatory purposes, they're probably not firing on discriminatory purposes as well. And that's why you'll often see HR departments will basically have the one person doing the hiring and also the same person doing the firing for that very reason.
So if it's a large corporation, let's say you interview with your potential boss, but then is HR technically the one who hires you, or?
Yeah, and in large corporations, it's a little bit harder to make that same actor inference because there's going to be so many people. There's going to be people coming and going. But in those situations, so I've also had clients who are large scale companies as well. The way they then adopt that same actor inference, not on the person, but on a hiring matrix. So a lot of smaller organizations will just go to an interview, meet with the candidate, and jot some notes on their copy of the resume or the cover letter. What these large organizations will do is they will find a way to create a measurement matrix that's very sterile, and all the points of evaluation, ideally, would be written in a way that avoids any decisions to be made on a protected class. So even, sometimes at interviews, just to be friendly, an employer might say, oh, do you have any kids? That would be a huge no-no because that infringes upon the protected class of the family class, because that's a parent who might need to take a kid to school, might need to take a kid to the doctors, might need to leave work early because there's been an emergency. So HR is always one of those very fine lines to walk when it comes to how do we create that same person inference when we're hiring and firing, and take away all the human element really of judging somebody, and kind of making it consistent to hiring just on a matrix.
I see. Thank you. And there is one more question. Someone's asking, do you have an example about, I guess, what kind of evidence would count towards possibly discrimination litigation? I'm guessing is what they're asking.
Yeah, and it really so these terms right here, and I'm glad I landed on this particular slide. the beauty of, I think, litigation is that these are the keywords that that I need to hone in on, whether I'm working for the employer or for the employee. So let's say if we have discrimination based on like the place of origin, nationality, or citizenship, okay? And an example of a question that would hit on that particular protected class, but it doesn't sound like it at first, would be something to the effect of at a job interview, if the interviewer said, "Oh, you know that you have a lovely accent. Where's your accent from?" And so having the candidate identify where they're coming from could then be a factor that that the interviewer uses to eliminate that person as a candidate. So when it comes to those really personal kind of questions, like where are you from, how old are you planning on having kids, all these kind of things, those are huge. Like there's such easy questions to ask, but because they're small talk, they're very friendly. But unless you're really certain you're going to hire that person, better not ask those questions, because the moment you ask, especially like women, I'm sure there's a lot of women in this presentation right now, ask a female candidate, "Oh, are you planning on having kids?" at the job interview, immediately women are going to think, "Oh, so if I say yes, you know, then I'm not going to get the job. If I say no, and I need to take a mat leave next year, they're going to pop me on it." It's one of those like you can't win for losing situations. So there are tons of ways to I'll put it this way: if it feels like you as an employee have been discriminated against on one of these protected classes, chances are your instincts are going to be right. And it's not so much about whether you're right or not. It's about what the evidence says. Is it going to be in written format? Is it going to be in text? Is it going to be in the way they treated you? Is it going to be in the way the employer has treated other people better than you, like took everyone to lunch except for you? And sometimes that can show up in multiple different layers. So let's say if we have a female employee whose religious beliefs don't permit her to eat pork. Okay, and so now we have issues of gender, we have issues of religion, and we have issues of place of origin, nationality. If the boss keeps taking everyone else to to Spalombos, which for those of you who don't know, it's basically Italian sausage, that's always going to have pork. That employee would probably have a pretty good case for being discriminated on multiple levels, because she's now missing out on a lot of employment-based opportunities to be collegial, to get ahead, all those kinds of things. So the examples actually can get pretty, they can get pretty broad. So I wouldn't discount it right out on the get-go. Follow your instincts if it feels like it's inappropriate discrimination.
We have just one last follow-up question. So someone's asking, I guess, in situations where an employer might ask you those kinds of uncomfortable questions, do you have a right not to share information about those personal questions?
Here's the thing. That's a great question, because the answer is not necessarily do you have a right? Because you can decline to answer any questions they ask you. You know, let's say if they wanted to say, like, well, what did you do during your gap year between university and your first job? You could always decline to answer that, and that doesn't really play into any of these protected classes. But if they ask a question that's not permitted, like, are you planning on having kids? You could. That's where you're stuck with. If you decline to answer, then it could be held against you. If you do answer and it's not truthful, sometime later, it's not consistent with the way you answered it. Let's say you get pregnant down the road, that's also perceived to be not so great. So here is the advice that I give to employees who are in that situation. Knowing that if they ask you that question, you actually have the upper hand here. So if you say no, not planning on having kids, or let's go with yes, I plan on having kids, and they don't give you the job, automatically, that's going to be like, I can smell it from a mile away. That's going to be a human rights grievance. And what happens in those scenarios, and I caution my clients who are employers all the time, is that you could very well be responsible to pay this person's paycheck for 2 years, 3 years, 5 years. They might take a look at the average of how long somebody's held employment at your job. And if it's 5 years, you're paying this candidate for 5 years of service and you're not hiring her at all because you have to compensate her for the job that she lost because you asked a question on a protected basis.
Well, that is really good information to know. Okay, so we are out of time, but thank you so much, Jo-Anne, again, for taking time out of your day to come and speak to us at AAVMP. We really appreciate it. And I'm really happy with the engagement and the questions that everyone had. So thank you so much. And if you have any additional questions, you have Jo-Anne's contact information. If you didn't get it from the screenshot, then you can always reach out to us at AAVMP and we can share her information with you. So thank you so much and have a good night, everybody.
Thanks. Bye, guys.
Bye.